Hello, my name is Melissa Worth, and I am a solicitor helping companies and individuals to resolve their commercial disputes. Each week, I am giving a short update about a recent case. A large part of my work involves advising clients about negligence claims, and so this week I have chosen the case of NDH Properties Ltd and Lupton Fawcett, which was a negligence claim against the solicitors and was handed down on the 16th of November 2020. In order to succeed in a negligence claim against a professional, the claimant needs to show, amongst other things, that the professional owed the claimant a duty of care. In this case, the claimant wasn't a client of the solicitor, but argued that the solicitor still owed the claimant a duty of care in any event. The claimant was a small company which approached a short-term lender in 2011 when the claimant was suffering financial difficulty. It was agreed that the lender would make a loan and that the loan would be secured against the claimant's property. The claimant was unable to satisfy the loan and, through receivers, the lender sold the property. The claimant argued that the lender's solicitors, the defendant, ought to have advised the claimant that, because of the high level of interest and the high level of fees, the loan was manifestly disadvantageous to the claimant. The claimant argued that the solicitors were therefore negligent. The parties had not entered into an express retainer, and this was not disputed, but the claimants argued that there was an implied retainer. The court had no difficulty in finding that there was no implied retainer, however. For there to be an implied retainer, the court said that what must be implicit is that the parties had agreed to enter into the contractual relationship of solicitor and client. However, here, the solicitors had no prior relationship with the claimant, for instance. The claimant's director had signed an authority that the defendant could act for him in the event that he were made bankrupt, but this had not happened here, and the defendant was fully aware of this. The claimant made no inquiries with the solicitors, and the solicitors made no direct contact with the claimant during the transaction. The court also had no difficulty in finding that the defendant did not owe the claimant a duty of care in tort. This was not because there was no retainer, as a duty of care in tort can exist independently of contract. The point was that the claimant's and the lender's interests were obviously conflicted. Therefore, the presumption must be that the defendant owed no duty of care to the claimant. The judge also stated that the claimant had no reasonable basis for assuming that the defendant was acting for it. The judge found that, as a matter of causation, even if the defendant had given cautionary advice to the claimant about the terms of the loan, the claimant still would have gone ahead with the transaction. The judge also criticised the way in which the claimant had calculated its claim for damages. It is fair to say that the judge's findings in this case were thorough and vigorous, understandably so. There are already limited circumstances where a solicitor can have a duty of care to a party that is not a client, such as a beneficiary under a will. But a finding that a solicitor owes a duty to the other side of a transaction with competing interests would cause shockwaves. In this case, the claimant was not represented throughout the loan transaction. Solicitors should always exercise caution when dealing with unrepresented parties. In such circumstances, the solicitor should consider spelling out to the unrepresented party that they should seek independent advice, and should also think about spelling out that the solicitor will only be responsible for the advice given to their own client. If you have any queries or comments about this case, please do not hesitate to get in touch. Thank you.